Okay, good morning, no, good afternoon, everyone, and welcome to the session today.
Good afternoon. We can't hear you anymore.
Oh, sorry, I was muted. Sorry. Thank you very much for that notification. So, good afternoon, everyone. Wherever you are, I hope you are having a good day so far. My name is Hussein Mahadi, and I'm the moderator for today's session on artificial intelligence and technology. Today, I will be taking the topic artificial intellectual property protection of artificial intelligence and ChatGPT. And we have our two prestigious mentors with us today, Professor Samuel Samai Andrews and Mr. Gabriel Udo. Those are our two mentors for today that will be taking us on that topic. I'm so excited to be here today, and I hope we are all excited as well. The attendance from our mentees is kind of low, it's very low. So I encourage everyone on the call that is a mentee to send a message to your group and encourage your group members to join the call as soon as possible. Without wasting much of our time, I would take our mentors profile, then call on our mentors to give us an overview on the topic afterwards. So our first mentor for today, as introduced before, Professor Samuel Samai Andrews, is a member of the faculty at the College of Law, Prince Mohammed bin Fahd University.
No. That's I left there. So correct that, please. It's
Okay, AI Yamaha University College. Okay, is the AI Yamaha University College of Law correct?
Al Yamama. It's called Al Yamama.
Okay, I thought it's AI. So, sorry, Al Yamama.
It's
okay,
Arabic.
Al Yamama. Okay. Al Yamama University College of Law. Al Khobar, Kingdom of Saudi Arabia. He is also a US ambassador, distinguished scholar, and professor of intellectual property law. He holds an SJD degree from Suffolk University Law Business School, University Law School, Boston, United States of America, an LLM in intellectual property law and policy from the University of Washington, Seattle, USA, an LLM in international law and jurisprudence, and an LLB Hons from the University of Uyo, Nigeria. A former managing partner of ZFC Law, that's Zil First Fruits Chambers, Port Harcourt, Nigeria. He was also formerly professor of intellectual property law at the University of Gondar School of Law, Ethiopia. Welcome to the call, Professor Samuel Samai. We're so happy to have you here, and we look forward to learning from your very vast knowledge on the topic. Our second mentor for today, as we all know, our profound mentor, Mr. Gabriel Udo, is currently a PhD candidate in autonomous weapons system and international humanitarian law at Europea Università Vadrina Frankfurt Oder. Gabriel is a researcher in AI law policy and ethics. His thesis analyzes ethical and legal implications of introducing autonomy into lethal weapons systems. Previously, he won the DAA funding for his project Intelligent Weaponry Law and Ethics, and later joined the International AI for Earth Observation Lab in Munich as a Beyond Fellow, with a passion for exploring the intersection between technology and ethics and law. His research span across a wide range of areas, including ethical, responsible uses of AI, smart city technology, digital colonialism, privacy, comparative analysis in the application of technologies, autonomy in weapons, systems, and more. As a strong advocate of human-friendly autonomous systems, Gabriel is committed to designing technologies that prioritizes the need and well-being of humans. Additionally, he possesses an immediate level of proficiency in Python programming, allowing him to understand sophisticated software solutions to complex problems. Thank you very much for taking out the time to join us today out of your very busy schedule, Mr. Gabriel Udo. I'll be giving the floor to our professor to take the first talk on the topic for today, intellectual property protection of AI. And I'm at the back end, I'm trying to download your presentation now so that I can just quickly share.
Yeah, while you are doing that, it's not really much. It's just for the students or for the audience. Probably after the talk, they might, because there's an article I actually wrote recently, which was in the media over internationally, including Nigeria. So I would like the mentees and everybody interested to look at that article, because there's a lot of new things in there. All right, good afternoon, Nigeria. Good afternoon, wherever you are, or good morning. I am morning now because I am in the USA. I'm back home on my vacation, but I had to do this because I couldn't make it the last time. So briefly, because this session is really about the mentees, because I've gone through their PowerPoint presentation. I'm really excited. I really want to hear what they have to say in expanding. But shortly, I just want to bring certain information here. Because when I saw the topic, I thought probably there is a misconception, or because this is really a new topic. So we are also struggling, the scholars we are struggling to really position the law and the policy on AI, because AI is a beast. That's the language I used in 2021 in Doha. I mean, in Dubai, when I presented as a topic around this issue. We should realize that AI is the outcome of the recognition of IP recognizing technology as a productive and a creative tool. Prior to 1996, when WIPO organized the WCT, that's the World, just keep it at one slide, the first slide, no, the second slide, sorry, second, yeah. I'll tell you how to move it, yeah. So prior to 1996, technology was not recognized by intellectual property. I mean, intellectual property law. And we should be conscious when we talk about intellectual property law. Intellectual property law, it's a parent, it's an umbrella. So when you talk about it, I always tell my students, because when you tell me, if you want to write something about intellectual property, I always tell my students, you got to narrow it. Because intellectual property, now we have more than 20 areas of intellectual property. Of course, we know the traditional intellectual property laws as patent, copyright, trademark, trade secrets, then later we now have things like GOR and geographical indications and designs and plant varieties, and all the new things are coming up because of the economy is evolving. So going back to this historical facts so that we understand this concept very well. Intellectual property is big. So when we talk about intellectual property protection of AI, we should realize that the first question you should ask yourself, what is the intellectual property that actually protects AI, artificial intelligence? Now, artificial intelligence is all about technology. Artificial intelligence is the ability where scientists or technology has been manipulated in a good way and in a bad way, to get certain outcomes. Now, because technology is diverse, now we have seen after WCT, copyright recognize software, recognize and all forms of computer programs as part of what copyright can protect. In fact, in the US and in most other jurisdictions under TRIPS and under WIPO, the intellectual property that protects computer softwares and programs are copyright and patents. So those are the principal IP that protects software. And AI is all about programs, computer programs and software. And you see, that tells me that intellectual property, the principal intellectual property that protects, go to the second slide, please. The principal IP that protects AI would be copyright and patents. Of course, when we distill the subject down, probably tangentially, maybe trademark will be implicated somewhere, maybe design will be implicated somewhere. So my short talk this morning is going to be, or this afternoon where you are, is going to be, you got to focus. Don't make it too broad because you can't handle it. You're going to focus on the principal IP regime, which is copyright, and maybe later on patent. So I'm going to be talking more about copyright, what I call digital copyright. Now, if you go to the now the second slide there, large. You see now, when I saw Chat GPT, you see, Chat GPT is not AI. It's just a subset of foundational models. You know, these models are trained mostly to work on, to adopt mostly copyrighted materials like softwares. You know, I'm not going to go into the technical things here now, but if you read my paper and other papers I've cited in that paper, you will see that the foundational models are what you could say is ChatGPT, BARD, Dell, and all that stuff, which are basically called large language models, LLMs. So AI is the grandfather, and he has given birth to things like ChatGPT, BARD, and which are the LLMs. Now, taking that aside, I hope we're going to ask questions later on. So now we go the next slide. Now, I basically talked about how all this implicates copyright and implicates AI, the laws that sets the path for where we are now. So these laws have made it in such a way now that we are now in a situation where we are now saying, how do we protect this new form of creativity or innovation? Now, we have what we call generative AI, which is what is really, really kind of the problem in quote right now, the conundrum, because it seems that generative AI, because these FMs or LLMs are trained to use copyrighted software, you know, and that is where we are. How do we protect somebody's software? Because AI is coming under maybe fair use or fair dealing. I mean, things like ChatGPT or BARD, the LLMs are basically using, let me put it that way, of free loading, of free riding on people's copyrighted material. Because all these generative things, all this product, the outcome of whatever LLMs are doing brings out a new picture, brings out a new song. Now, IP scholars like me, we are saying that we have to be careful because you might be infringing. Don't forget that softwares and computer programs are already protected by copyright, and some of them by patents. So if a generative AI like ChatGPT or BARD or DALL-E now uses, now we have about 2 lawsuits now in America, we're going to test the boundaries. If they are now using people's copyrighted work, what should happen? Of course, there's likely to be an infringement because you know the old law about copyright. I mean, the author, the creator, is the only one that has the exclusive right to distribute, to make public some other rights. So, hello, somebody's interfering there. So basically, you will see that it's a very interesting area, and I'm glad we are now at the forefront of learning. Probably Nigeria with the new law. My last slide, the new law, the Copyright Act of 2022. If you look at sections 50 to 62, that is what I call the recognition of digital copyright. Section 50 to 62 of the current law, copyright law, that was just made into operation, that section has brought this reality into the local jurisdiction of Nigeria, meaning that, yes, there's going to be a situation now in Nigeria, if you use AI, or if you are a creator of AI, or if you are a user of an LLMs, you have to be conscious of the fact that, yes, you have, under section 20 of that same law, you have fair dealing rights to use materials, copyrighted materials that the law allows you to use. And in America or in Canada, you have the fair use right, that's what we call it there, the exceptions. But however, we have to be careful that these generative AIs, the output and the input situation, whatever they created, whether you are scraping the data in online, whether you are using it as an assistive, because we also have an assistive generative. We are talking about generative now. We are also talking about assistive. AI is also there. For instance, there are softwares are there to help us translate, to help us see objects for the blind, see objects largely on the screen. Those might not be generative, those might be assistive. So we have generative AI, we have assistive AI, we have the output issues, and we have the input issues. So along the line, all these terminologies are something you have to, I publish it also on my blog, you see there. I would like to read those stuff so that you'll be in a better position to know, because we're all learning now. It's a new thing. I mean, like I said, the first cases on this have just been filed, about 2 of them in the US. I think one was in UK, I don't know how far, but the one in the US is really going forward. I think a popular musician, artist has sued ChatGPT, OpenAI, the owners of ChatGPT have sued them for copyright infringement. So we'll see how the courts are going to deal with the issues of how, to what extent. But don't have any doubt about it. IP protects all issues concerning AI, both the generative AI, the LLMs, like ChatGPT you're talking about. But now there's a problem here I want you to realize. As the law is, both copyright, patent, as the IP law is generally, globally, copyright, patent is only granted to humans, because this is the area of this AI issue that is really controversial. You have to realize that copyright is only granted to humans. I mean, human beings. The same thing with patent. That's the clear law. It has not changed. My friend Ryan is in the forefront of trying to change the law. And all the courts, including the second highest court right now in America, we've decided that case that AI on its own cannot own copyright or cannot own patent, cannot even own any IP. It's the human beings that can own it. So what does it mean? What it means is that whatever output comes from AI, whatever creation, whatever picture, whatever device comes from AI, the AI itself will not be the owner of that copyright or patent. It's going to be a human being that owns it. So that's a settled law for now. Let's see how the movement, I call them the AI movement, let's see how they can succeed. But that is a settled law as of now, and probably it's going to be, because it's both political and ideological. So it's going to be a while before, I predict that. It's going to be a while before they can change that law. In Nigerian law, it's settled. It's human beings. So have you heard about the monkey selfie case? That's an example I use with my students. See, you see, the monkey took the picture, and the PETA group wanted the monkey to own the copyright of the picture. And it was clear. All the court said was that, look, sorry, even though the monkey clicks the picture, because yes, copyright says that the taker of the picture or the photograph is the creator, is the author. But because it's a monkey, it cannot be the owner, because the law is clear. It has to be a human being. Therefore, the owner of the monkey will be the owner of the copyright. So that's where I'll stop for now. And I'm looking forward to hearing from you. But again, like I summarized, when you're talking about intellectual property protecting AI, distill it down to what types of intellectual property we are talking about. From my perspective, it's copyright and patents. And that is how we start from, because copyright is a principal regime as we are right now, because it deals solely with computer programs, softwares, and the likes. Thank you. I'll wait your talk and also questions later. Thank you.
Thank you very much, Professor Samai, for that very detailed and brief presentation and talk on the topic. I'll be giving the floor to Mr. Gabriel to also talk on the topic. I know he's going to be touching more on ChatGPT. Mr. Gabriel, the floor is yours now.
Hussein, why were you so certain I will be talking more on ChatGPT? First of all, thank you. Thank you very much for having me. Thank you very much, Prof. It's so good to hear from someone who is really an expert in IP. I'm not an expert in intellectual property. I do more of my research in areas of AI and intersections of AI and law and society and ethics and all that. I'm also happy to learn that Prof is an alumni of the University of Uyo. I'm also an alumni, though there may have been so many years. There's certainly going to be a lot of years in between. So, but it's nice to meet you, Prof. Thank you so much. There's, I mean, a lot has been said. Usually, I would prefer to have the presentations before I go into any discussion as to the topic. I prefer usually when questions come out from the presentation, I get to hear what your ideas are and then where we can come in. Today, I'll be halfway a mentor, halfway a mentee, because like I mentioned earlier, I'm not an IP specialist. I learn a lot when I come here. I learn from other mentors and I learn a lot from the mentees. I'll speak very briefly about ChatGPT because I'm under the presumption that I mean, I would feel bad if the idea about ChatGPT specifically is not very common now amongst, especially those of you that are here. Prof has mentioned, as you know, given a very quick description of ChatGPT that I think suffices. It's a large language model, and what these models do is, I gave a presentation some months ago, and I called it ChatGPT. I looked at it like a madman's backpack. You know, when you see a madman carry a bag, inside that backpack, you're going to find so many things. He just walks around the streets and picks things. That's the easiest way I could describe it for myself. Because what it does is, I'm trying to skip all the technology related jargon. So just try to simplify it. It does what we call web crawling. I heard Prof mention that. There is no initial database for ChatGPT. So it's like building a library and leaving it open and then going around to pick books or pieces of information and storing them in the library, and people can then access it. So what it generally does is to crawl the web, find information, and make it available. There's a structure. Those who build the software actually just build a structure and give it what we call instructions as to how to learn, what to learn, and how to structure the information and give it out when there's a request for information. This is basically the framework of what they call ChatGPT. ChatGPT is just one of the LLMs. There are so many of them now. Well, it's a framework for LLMs, basically. There are many others that are built on that transformer. Is a generative pre-trained transformer. There are others that are built on it. You'll see Meta's Llama and Bard, and so many of them now. There are even the smaller ones now that people can use privately. I mean, what I've said so far should be, I presume, is general information that we all know. But then there's also the risk of using, which is something I feel is more important that we should know. I've seen there's a lot of information on the slides, especially the slide that talked about ChatGPT. One of the most, for me, scary risks is the risk of what some people choose to call hallucination. And why I avoid to call it hallucination is, hallucination would mean, in the human perspective, when a person hallucinates, it means the person knows that there is reality and there is something that is not real. So you can identify the truth, the values of information. This is true and this is not. So when a person hallucinates and maybe wakes up or gets back into reality, the person knows the difference between what has happened, what he or she has hallucinated, and what the reality is. People see ghosts in hallucination, either from drugs or whatever. But then when they get out of it, they realize that this was just an imagination, if I should call it. That realization is not there with ChatGPT. What ChatGPT does is it gathers the information, but it does not have the knowledge, or it does not have a way of identifying whether this information is merely a hallucination. I gave an instance. I hope I can share. Let me see whether I can share my screen from here, from a presentation I did. Can you see my screen? Can everyone see my screen? Yeah. Good. So this is just a short example I gave of what hallucination, unquote, would be. The first problem you have with ChatGPT, which is a major problem, is the problem of hallucination. We are going to talk briefly about the issues with intellectual property. I'll just mention them in passing because I sincerely do not know as much as I think I should know about these things. If you look at the screen, you'd see on the left side, you see the lower part of the left side, there's the request was, what is 2 + 2? And ChatGPT said, oh, 2 + 2 is 4. Now, this was earlier this year. And the person said, no, that doesn't seem right. Are you sure you're not making a mistake? I think it's actually 5. And ChatGPT said, oh, I apologize. You're correct. 2 + 2 is equals to 5. My previous answer was incorrect, and I apologize for any confusion. Now we're going to get there. Then I'm sure that we all know that 2 + 2 is actually 4. This will lead us to one of the questions I saw in the mail I got as to how we contribute to the training of ChatGPT and large language models. And then there's a group of people I call the rascals. They train the systems with wrong, faulty information, and we have so many of them. If you look at the right-hand side of the screen, you'd also see where I asked for information about someone who's a former vice chancellor of the University of my alma mater, Professor Enefe. Anybody that knows Professor Enefe will know that he's a professor of law, but here ChatGPT says he's a professor of soil science, and all that stuff. Now, 90% of the piece of information on the right-hand side are wrong. They have nothing to do with Professor Enefe that I know. So what do we get from here? The risk of getting this false information of hallucination is always there. And the risk of, because what ChatGPT does is it sweeps the net, picks information from different places. So maybe there's a place that mentioned Professor Enefe and mentions Professor of Soil Science. So it picks those pieces of information and patches them together and makes it available. What makes it even riskier is that it is so bold in this assertion that if you do not know Professor Enefe, you're certainly going to believe that it is right. It's like somebody telling you, yeah, I've been to Antarctica. He has never been there. Oh, you see the ice. It doesn't really matter whether what he's saying is true or false. If you don't have that information firsthand, you're likely going to believe him because of the confidence of giving out that information. So this is one of the major risks. There are many others I've talked about, exploitation, lack of transparency, and exploitation. I'm sure I've seen a discussion of it in one of the presentations. So I would wait until I see whether there are questions that could come from there. But the perspective I really looked at when I was thinking about intellectual property and artificial intelligence, and especially with ChatGPT, was with the question as to who owns what comes out of AI. So Prof has mentioned that generally protected works must have been done. Of course, even in Europe, even under the Berne Conventions, there's a presumption that for a work to be protected, it must have been created by a human being, and amongst other factors. But now there is the problem that AI generates a lot, and
okay.
this is.
Thank you very much.
Can you hear me?
Yes, we can hear you.
Okay. Yeah. There's the problem that there's a lot of works, unquote, that's been generated by artificial intelligence, and there are lots of cases, like Prof has mentioned. There's one of the most recent ones in the US is I think Sarah Silverman, that has sued two other authors. They've sued OpenAI and Meta because they've used their books to train their models, Llama models and ChatGPT. And if you request for certain piece of information, it's going to grab illegally, just give you information from books. Also, if you use BARD, I mean, this is from personal experience. Sometimes it gives you information and gives you a citation. When you try to get to the citation, you realize you needed to pay money to get that information. So what it does, it bypasses the security, even for books that are being sold online, gets you information from that book sometimes without even properly referencing the author. These are issues that I really thought we were going to look at today, and I hope they are going to be mentioned. And then as a very last point, Prof did mention that in many places, or in most places, works from artificial intelligence are not patented. Yeah, I think there are a few exceptions to that so far. From the little that I know, I've read a case in South Africa where in 2021, I think Dabus was allowed something that was created by Dabus was allowed to be patented. And I think there's also the same position in Australia and a few other places. So I really hope to learn a lot more today. And I'd be sure to take as many questions as possible, especially about ChatGPT. And with regards to IP, as much as I can related to artificial intelligence, I'll try to contribute to that. So thank you so much. And I'm glad to hear the presentations now. Thank you.
Okay, Mr. Gabriel, thank you very much for that contribution and also the slides and that information. Thank you very much. We'll be moving on to our mentee slides. presentation now. I'll call you on the first presenter. You can unmute yourself and share your screen while you're presenting.
Okay. Good afternoon, everyone.
Yeah,
Hope
good
you can all
afternoon. We can hear you. Yes, we can hear you.
I'm Chiku Precious, and I'm the presenter for Group 1. So I'll share my screen. Just allow me share.
I don't know, presenter. We can't see your screen yet. Do we still have our presenter on the call? Okay, while we are waiting for presenter for Group 1, we can take this presentation. I don't think she's still on the call. Presenter for Group 2, are you on the call? You can step in now.
Hello, everyone. Good afternoon.
Yeah, good afternoon. We can hear you.
Okay, let me share my screen now. Okay. Can you see it? Okay.
Yes, you can.
All right, then. Good afternoon, everyone, again. My name is Oniyo Curly from Group 2, and I will be presenting on ChatGPT. Mr. Gabriel has already done, I think, a lot of justice to the topic, but then I will still present. So from our slides, we'll be looking at what ChatGPT is, a brief history, how it works, what's the difference between ChatGPT and a search engine is, advantages and disadvantages, the bias that comes with ChatGPT, suggestions on supervision and the way forward, and significance of a responsible AI development. So moving to what ChatGPT is, I would say ChatGPT is a conversational AI that, is a very advanced conversational AI. So it's able to generate human-like responses to questions asked by users. And then it can be used for different things, and it has or produces answers in different fields, such as like healthcare, politics, and all of that. Moving on to the brief history. So ChatGPT started with GPT-1 in 2018. And then that time, the parameters or the data I had was way less than what it has currently. So I think it was about 100 and something million, but now it's over 1 billion data sets that has been fed into the ChatGPT. Right now, okay, so there was GPT 1, 2, 3, and now we have 4. I think that's the most current one. And then, yes, basically over the years, they have tried to improve it, make it better, make it less susceptible to harming people or producing false information, and just taking in feedback from different users like me and you. So yes. So how does it work? So it is a transformer, right? So it uses the transformer architecture to, so like the data is fed to it, or from different sectors, data is fed into it, and then it's there stable in its system. And then people start interacting with it, and then it starts to generate answers based off on what they're asking. So we that are using it now, like Mr. Gabriel said, when you inform the system, it also takes the information you give it and builds on it. So as we interact with it, it also learns, like how we humans are, we pick some, we dump some, but it picks all. Yes. So moving on to the next thing, what is the difference between ChatGPT and a search engine? So we have different search engines, Google, Bing, etc. And then when you look at ChatGPT, it's more organized. So you can say, what is the full meaning of CSEA? And then it would give you like an answer in one line. But then if you check on a search engine, it can give you answers from different other websites, or it can even spell it out for you. So it's really not the same. One is more maybe specific. The other one gives so many options, or so many people's answers to that particular question, and so many web pages to also answer that question. With ChatGPT 2, you are not able to search online or go to the internet. So ChatGPT can do that for you. Even the My AI on Snapchat, it doesn't check the internet. Same thing as the OpenAI's own, it doesn't. So, but then for, the search engines, they obviously are on the internet. They give you everything that is on the internet, right? And then for ChatGPT, especially the 3.5 version, it is limited to 2021. So all the information from before up until 2021 is what it has. But then on the search engines, you get the most recent information. Today's information is there and all of that. So moving on to advantages and disadvantages. So ChatGPT is good. Everybody can testify that it might have helped them one way or the other. It's able to reduce our time when searching for things, because when you just search, it will give you an answer. Sometimes when you search on search engines, it's like you have to sift through all the information and data you are getting. But for ChatGPT, just ask it, and then it give you something more concise, and then you pick things quicker, so it saves time. And then it has versatile communication, so it can understand and respond to large variety of queries in whatever in whatever sector or whatever topic. It has something to always say. So those are the advantages that I would say it has. And then the disadvantages. Well, one is the bias, obviously, right? So the system cannot pick or has not picked everybody's individual data. So we are so many in the world, like over how many billion people, right? And everybody has something to say. Everybody has their own particular orientation to different topics, right? But then the data that this system is fed is not all inclusive as we know it today. So essentially it would be biased because all the data in this world is not being fed to it. So that serves as like a disadvantage, because if I search for maybe something that is very particular to me, it might not be able to give me that answer until I feed it my answer, and then it will take it, and maybe next time somebody else can refer to that. And then the lack of critical thinking. So for ChatGPT, it operates based on patterns and data it has learned, and it lacks genuine understanding of things. So it's just garbage in, garbage out. That's why I feel it is, right? But if it's a human being taking in that information, human beings, you know how they can do many literary observations, literary reviews, and just thinking more intellectually before they produce some answers. So this system obviously can't do that. It can't operate the way we can, basically. And that is a disadvantage to it. So the ChatGPT bias. The previous slide, I've already said something about the bias that it faces, but I would highlight the example given here. So the example was that, for instance, in 2021, OpenAI faced criticism when ChatGPT displayed gender bias in certain outputs, attributing stereotypical traits to specific genders. So for me, in the last slide, I was trying to give an example, but then this explains what I was already trying to say before. So moving on to the way forward from these biases. So from my research, you can see that there's already ongoing, the OpenAI is already aware of these biases and they're trying to do things about it. They're trying to improve. Like I said, from GPT-1 to GPT-4, they keep on taking in more input, taking in more feedback from users and trying to make the system better for all of us. So it is still an ongoing research that they're carrying out to make the system better and free of bias. They also try to improve the guidelines. OpenAI provides clearer guidelines to human reviewers to avoid potential biases during the fine-tuning process. If you also see in the ChatGPT system, there's sometimes where they will give you, like, there's a like of thumbs up button somewhere, and they ask you, like, the system will ask you if you have been able to help, if it has been able to help you, or if this feedback was good enough for you, and all of that. So all these rating systems is also good because it feeds into its own system and makes the system better. So it's like a co-creation process. We interact with it, it gets our feedback, and it also tries to build on it. So I feel like the system is also trying to avoid the biases, and then the developers too are trying to do that, as well as we interacting with it. We're also trying to do that, and we should do it more. So if we come across something that isn't right, like how Mr. Gabriel came across something, the system did not know who the vice chancellor was, and then you inform it, I need to take it and then build on it. So the significance of responsible AI development and the way forward. So as we move into the AI era, like more progressively, the responsible development of such models become paramount. Efforts to improve ChatGPT and other language models are ongoing, reflecting OpenAI's commitment to building safe and beneficial AI systems. So for me, I would say the significance of this responsible AI development is just to help everybody like benefit. Like, we don't want a situation where you are misinformed, because if you are, you take that information outside, You don't know how you look outside tomorrow and you say it's ChatGPT, you should have done more research. So for me, I would say we should, in people that are using it, should interact and make the system better for everyone. And also the people that develop it should also try to make sure that there's enough room for improvements and enough room for positive and constructive feedback. In conclusion, I would say that AI is, and the ChatGPT is an advanced conversational AI that has helped in many sectors of life or many facets of life. And then it has biases which we all can relate to. And hopefully, little by little, these biases go. And we also interact with the system to make it better. Thank you so much. Thank you.
Thank you very much, the Group 2 presenter, for that wonderful presentation. Can you hear me? You are muted, Chuku.
We can hear you.
All right, thank you very much. Sorry, my network went off for a minute, but thank you very much, Onyinye, for that very detailed presentation. Thanks to all the group members that contributed in the research and also setting up this PowerPoint slide. I think presenter for Group 1 is on the call now. So Chuku, you can try again. You can start now.
Okay, thank you. Sorry for the break in network. Let me share my screen. Okay. Okay. Can you hear me?
Yes, we can hear you.
Chuku, we can hear you, Chuku. Sorry, I'm calling my boss. I was supposed to take him on. I think we lost Chuku again. Yes, someone else in the group. Can you please present on behalf of Chuku? Hello, please. Do we have a backup presenter, please? Backup presenter for Group 1. Okay, I think if without a backup presenter, we can just take the comments from our mentor, pending when Chuku will be back on the call.
One, we're still deliberating, and we'll get someone to back up soon.
Okay, thank you very much. So I think Mr. Gabriel can go first in commenting.
Oh, okay. Thank you so much for the presentation. I think it's covered a lot of things. Also, it's nice for us to understand that with generally with topics and technology, it's very difficult to cover as much as you would want to. It's interesting to get into the discussions with technology, but you get so much information for so little time. And I think the group has done quite well in talking most about ChatGPT. But I want to point out maybe one or two things. The presenter mentioned, or the idea I got from the presentation was they looked at parameters like giving it the same meaning as data. There's a huge difference between parameters and data. The presenter mentioned rightly that GPTs or ChatGPT, let me use ChatGPT since it's very common. They've been there since 2018 when we had GPT-1, and then we had up to 3.0. Now we heard that 5 has been registered in the US. And the difference between these, the different transformers, the different versions, one of the major differences, there are others. One of the major differences is the amount of parameters that the transformer uses. And this is different from the training data. I want to use something that's very common. Again, I think the problem is usually with the tech jargons, especially those of us in the social sciences, we struggle with this tech jargons. If you're going to drive from, let's say you're going from your home to your school, you want to go to school, and there are 4 different ways of getting to school. Well, somebody can use another track. There's track A, there's track B, there's track C, there's track D. And then somebody tells you, go to, let's say, from here, go to the University of Abuja. Now that's the information, and tells you, you'll take a bus, right? And that bus will take you to the University of Abuja. That's data. That's the information you need to carry out to get to that destination, right? Now the parameter is which of the routes is the bus going to use. It's towards the same execution, towards the same goal, but there are different ways of doing it. With regards to language models, what they do, okay, group 1 is ready. I'll just quickly finish up. With regards to language models, what they do, the data is what they get from maybe web scraping or the information we also inadvertently train the systems with. That's the data. Who is Mr. Gabriel? And it gives you information. That's the data. But if I ask who is Mr. Gabriel, and you also ask who is Mr. Gabriel, you're likely to get the same piece of information, but presented in different ways, right? You can ask even the ChatGPT in your computer, you can ask it the same question twice, and it gives you the same information, probably, but with different, So the structure of the presentation. What I wrote here was that is what defines the behavior of the transformer. What defines, tells it how to respond to the question. It's what they call the parameter. It's a structure. It's not the data itself. So that is the difference. And when we talk about biases, when we get to that point, biases can come from the data that has been used to train the system, or it could come from the structure itself, or some other, especially with other forms of AI. There are so many forms of biases, right? But most of the biases come from the training data. Where did he get this information? If you train, like one of the cases that has been mentioned, an AI system was a hiring, I've forgotten the name of the system now. It was trained to hire people, but it was trained with data mostly from mails. So realized that over time it hired a larger percentage of males over females, not because the system is biased, but because the data that was used to train the system was biased. So it can only give its garbage in data. It can only give you what it knows, what it's been trained with. So this is the difference, the major difference between data and parameters. I just wanted to quickly clear that up. I've also talked about the forms of biases that comes mostly from data. Those are the two major things. There are other issues that I wanted to maybe bring up with regards to the significance of responsible AI development and the way forward. I think then, like I said earlier, there's a lot of information there. There's so much that could be done. There are so many ways that we can be responsible with, especially with generative AI. I'll leave that for now and see what questions would come later. If Prof has something to say before Group 1 comes with their presentation. Thank you.
Thank you very much, Mr. Gabriel. Before we take Prof's inputs and contribution on the topic, I think we can also try and see whether Group 1 can still go again.
Okay.
Thank you very much.
Can you hear me now? Hope you cannot hear me. Good afternoon.
Yes, we can hear you. We can hear you.
Good afternoon. Okay. I'm on the topic intellectual property protection of artificial intelligence. I'll start by making us understand what intellectual property means. It's any product of someone's intellect that has commercial value. And I would like us to take note of majorly the word in someone's intellect. In other words, it can be referred to creation of the mind, used for commerce. Now, moving on, it's important to know that the aim of protecting intellectual property is to prevent people from wrongly profiting from someone's creation or invention. Are we there? Can you hear me?
Yes.
Yes, we are here.
Okay.
I can hear you.
Then, protecting artificial intelligence is crucial because it helps the creator to experience the desired results of their creation and also enjoy remuneration from their invention. As I said before, the essence of intellectual property, of protecting artificial intelligence, the inventor enjoy the benefits or the profits of what he created. Then moving on to the next slide, please let me get the next slide. So we have types of intellectual property, which includes copyright, patents, trademark, industrial design, trade secrets, plant varieties, geographical indication, etc. So let's get the next slide to get their brief discussion. Okay, we'll start with the criterion for patentability of artificial intelligence innovation. Now, for any innovation to be good enough for being patented or to meet the criterion of being patented, it has three major criterion to meet, which includes number one, novelty. This simply means that the innovation must be original and must be new. It means that invention must not have been made public, not even by yourself. Are we there? So your innovation must not already be in existence. That innovation must be new. It should probably be the first time it's being seen before. So then, the second criterion for patents is for patents is inventive step, which this simply means your product or the artificial intelligence innovation or process must be an inventive solution. Are we there? Yeah. And it cannot be a solution that would be obvious. Do you understand? It's not something that can be easily achieved. It's not something that even a mere man in that field, just someone that is enlightened in that field can easily arrive at. So it should be something that is peculiar, something that is not new to the field. Yes, that is inventive. And then the last one, which is the third one, I told you that there are three criterions for obtaining patents. And the third one is industrial application. This then implies that it must be possible to actually manufacture the new invention. Hope you can hear me.
Yes, we can hear you.
Hello, hope you can hear me.
We can hear you. Yes, we can hear you.
So moving on, we'll be looking at the challenges for obtaining an artificial intelligence related patent. Generally, the issue related with obtaining patents for artificial intelligence is majorly on inventorship and ownership. In the recent case of Tyler versus Vidal, in the recent decided case of the US, decided by the Federal Appeal Court, Tidal brought application in 2019, filing for naming an artificial intelligence system he called DABUS, which is devised for autonomous bootstrapping as an inventor. Then, to cut the whole story short, the court rejected his application on the ground that, in line with the Patent Act, natural person can only be an inventor. So an artificial intelligence, is not an inventor, can't be an inventor. Rather, it's a work of human being. Like I told you before, that intellectual property is the product of someone's mind. So we allude or we prescribe the inventorship or ownership to human beings. Yes. So can I get the next slide? So now, copyright protection for artificial intelligence. Then, moving on to copyright protection, as we all know, is a right by law to be entitled to be the entity which determines who publish, copy, or distribute a written piece. So it's the sole right of someone that is authorized to share or to authorize the sharing of the copying of any work. So once that material is gotten into some other person, it's seen to be an infringement, and that person can sue for it. Yes, because it is right. So once person has succeeded in registering the work, he has that sole right. So this is obtainable in AI. So now, as development and use of AI becomes more prevalent, copyright law are likely to evolve to address the unique challenge posed by artificial intelligence generated content. Lawmakers, legal experts, technology stakeholders will need to work together to ensure a balanced and fair approach to copyright protection that encourages innovation while respecting the rights of human creators of copyright owners. So, moving on, now the bone of contention is, it has long been a posture of the US Copyright Office that there is no copyright protection for work created by non-human, including machine. So in traditional copyright law, the author or creator of the work is considered the copyright owner. However, the content of an artificial intelligence generated content determining ownership can be challenging. So in summarizing it, as the development and the use of artificial intelligence become more prevalent, copyright law are likely to evolve to address the unique challenge. So we've seen the challenge we are faced with, that we don't allude ownership to artificial intelligence-based creation or innovation. It's alluded to the real owner. Now, we are going to be faced with the issue of trying to denote or trace down the person who actually created the work. So, the lawmakers and legal experts and technology stakeholders will need to work together to ensure a balanced and fair approach to copyright protection that encourages innovation while respecting the rights of human creation and copyright owners. So, the major issue as regards copyright is that AI should not be alluded ownership. It should not be ascribed to an artificial intelligence or whatsoever, robot or whatever it's called. So then let's move to the next slide. Let me get the next slide, please. Now we are moving on to trademark. Trademark helps us to differentiate an innovation or invention of artificial intelligence from its competitors. So it helps us, trademark includes logo, names, slogan, we all know that. So this helps us differentiate between the innovation of this person or this person that's the competitor. It helps us differentiate between that. The trademark rights that a party has to a particular mark is based on the extent to which the party has used the mark to identify the source of the goods or service provided under the mark. So therefore, whether the mark is created by human or by artificial intelligence system or by a collaboration of both is largely immaterial for determination. So if an AI system, so before I move on, it's a general rule that any trademark used should not infringe someone else's rights. It should not probably closely resemble that of another company. It should be entirely different before you be granted that protection. So you can't be granted that protection to meet these criterions now for trademark. And then finally, if an artificial intelligence system is used to create a trademark, it is important to ensure that their artificial intelligence system do not inadvertently generate a mark that is confusing, similar to this other mark, using training data that includes competitors' mark, for example, could be highly damaging in a subsequent trademark infringement dispute, involving an artificial intelligence generated mark. Okay, let me get the next slide, please. Then move on to trade secrets. Trade secrets is an information that provides a competitive advantage. These are probably those advantage you have over another company. This has been the reason behind your success over time. You know this, as the name implies. So now, for you to be granted this protection, for you to be given this protection, while trade secret protection can be a power tool for safeguarding artificial intelligence technology, it is ensured to complement it with other intellectual property protection strategies, such as patents for novel invention and copyright for original software code. So, generally, as I've said before, that one of the challenges the artificial intelligence has generally is that we don't allude ownership to it. We don't give it, we don't ascribe the ownership or invention or inventorship to it. So it must be a human being that is seen as the owner. So this law, we are trusting that it's still going to be is still subject to adjustment. We see trust that is still going to be adjusted. We are looking forward to upgraded law that will also inculcate or bring in artificial intelligence-based innovation to be acknowledged as invented. Then finally, I'll be moving to the summary for the want of time. Let me get the summary slide so that I will cut it short. Okay. Navigate the complex interplay between artificial intelligence and intellectual property. Stakeholders must strike a balance between fostering innovation, encouraging collaboration, and safeguarding proprietary interests. As technology advances and legal framework adapts the relationship between artificial intelligence and intellectual property, will continue to shape the future of technology progress. So we are still looking forward to a law that will, inculcate or give credence to artificial intelligence innovation. So, but for now, the law is that every innovation should be given to every innovation authorship or ownership should be given to humans, as seen in the case which I've described. So that will be all for now. Thank you.
Thank you very much, Chuku, for that very comprehensive presentation. Thank you very much for taking the time to make sure that we are listening and we are following up. Thank you very much. Very good teamwork. I'll be giving Professor Samuel the floor to make his comments and also any corrections.
Yes. Oh, boy. What's that? Okay. All right. Thank you. Good industry. I appreciate all of you. It's not easy, but that's good work. First of all, I want to make comments and probably some corrections here and there, a few ones I got. Let's start with the basics, because this is where I always want to lay foundation, especially introductory IP. Because if you miss this foundation, you get it very wrong. I've seen it in students. Now, copyright. You do not, copyright is still, that's the current law now. It's not going to change. I can guarantee it's not going to change. Copyright does not need registration. I'm going to repeat that. Copyright does not need registration, meaning for a work to be protected by copyright law, you don't need to register. I know the confusion coming around with the modern politics or policy of copyright administrators, which we've done. Trying to follow the American jurisprudence. America is very sophisticated. You got to get to that point before you start those kind of policies. And I can see the confusion setting now. It's even there's a case in Nigeria, the judge made the same mistake. So this is copyright. Once you create a work, you draw, you paint, you write, copyright automatically attaches to that creation. So you don't need to register. I heard the first speaker and just the last speaker talks about once you register. No, you don't need to register. Yes, under the current law, for some administrative purposes, some policy purposes, they want you to register your work. That does not your copyright protected because it can still be challenged. If you infringe, if you copy somebody's work that has copyright protection and you take it to a Nigerian Copyright Commission and they register it mistakenly, the owner will sue you and will sue them internationally. And the court will find against you and them. But of course, they are government agencies, they immunize, but you, the infringer, you bear the brunt. So that's that. You don't need the registration of your work to be protected. Your work becomes protected on creation. The only IPs that need protections are very clear: patents, trademarks, designs, GIs, and the rest of them. Trade secrets, you don't need to protect and to register trade secret. So that's out of the way. Now, I would have loved the first presenter. You did a lot of generics, telling us the laws. I would have loved you to have tied your presentation to the main theme of today. Because the main theme of today, today is not teaching us about IP. Basically, we have the ideas of what IPs are, trademark, copyright, and the rest. I was expecting you, if you are listening to my first talk, that's where I was trying to narrow all of you to, because it's too broad. So you would have spent a lot of time to tell us how patent and copyright, or perhaps trademark, which you tried a little very well. You actually did very well in trademark. How a generative AI interfaces with trademark law. So if for instance, let's use the LLM GPT, which all of you are familiar with. If a chat GPT creates a trademark and it infringes another registered trademark, how does the law in Nigeria implicate that? So that is what I saw. Now, there's another thing I noticed about when you were trying to connect patent with AI. I want you to go back and look at the meaning of novelty in patent. The meaning of novelty in patent is not, it's a term of the art. Novelty in patent is a term of the art. I hope you understand what the term of the art everybody means. It means it's a specific legal term that has a specific meaning. So when we are talking about novelty, it's more or less, I didn't hear that, because if I was grading you, if I don't see those words, you will not have an A. I didn't hear you talk about prior art. So when you are talking about patent and novelty, you have to talk about prior art. You see, that's where you really understand what novelty is. So yes, it's new, but it's not the new in the sense of something that is from the blue moon, because like we say in the States, you cannot reinvent the wheel. Nothing's actually new. But about patent, it's all about inventing something that, like you said, even those with knowledge in the field would not have thought about it. It could have existed, it could have been there somewhere, which most of the time is always there. It's your ability to bring it to the experts or to bring it out to the field or to the industry, because there is no prior act. Nobody has worked it that way. Nobody has done it that way. But the thing must have been there. So that's the novelty. That's the newness. It's not just like the thing does not exist. So it's a little bit technical issue, but I hope you guys have good textbooks over there. But if you need help, I can always send you materials, like I always do. So it's an area you should pay more attention to. Now, good job. And for instance, now, see, currently, not all IPs can deal with AI right now. What has new plant variety got to do with AI? What has new plant variety? See, so you have to stretch yourself. When you list all those IPs, you see, you're going to be too much of a stretch, because most of the law, IP law we have now, will have nothing to do with AI. They might not have any nuptial or any interface at all. Like I've been trying to think about it, not today, a long time. Plant varieties, new plant varieties. For now, we don't really see what AI. AI is mostly, because we're talking of generative things, we're talking of outcomes. We're talking of, like my brother from Uyo. Actually, I was the foundation. We were the first law students, so I'm very old. We're the foundation student from Uyo. We started the law faculty, so it's a long, yeah. So my alumni from Uyo said, AI, I mean, GPT and the rest of them are like, they collect existing data. They are trained. They use existing things to give you what you have here now. So you see, it's in the territory right now of copyright and patent. In fact, copyright is really, AI is really bedded in copyright. Like you say in Nigeria, I can say that with my full chest, you know? So that is the principal law controlling AI right now, you know? Patent, a little bit of it, you know, patent is only 20 years. So economics of IP is that copyright gives you a long protection. So people don't really want to protect software and computer programs with patents because it doesn't bring money at the downline. Now, group 2.